For the Disabled Persons Protection Commission is here as well, and the title of our workshop is Client Concerns and Complaints. We're going to provide you an overview of how the Department of Mental Health investigations regulation operates. Prior to that, and we're going to begin today with Ralph Calderero talking about Chapter 19C, the Disabled Persons Protection Commission statute, how it works, how it resolves clients' concerns, and then I'll follow up and talk about the DMH investigations. And what Ralph and I both find most valuable to these sessions, I believe this is the third or fourth that we've done together, is try to hear your concerns and questions and try to answer them. So we'll try to leave ample time for you to ask your questions. So without further ado, I'd like to introduce Ralph Calderero.
Thank you, Chair. I think everybody should have a handout. If you don't, there are some extra copies on the table in the back. I'm just going to briefly go through the material and then explain very briefly what the material is. The focus of my presentation today is going to be regarding the importance of reporting abuse and how the 19C system deals with abuse once it is reported. It's critical, however, that the importance be placed on reporting abuse, because unless we know about it, there's nothing we can do about it. So it's imperative that you, as individuals who work in the field and who may be clients of the department, that when you see or suspect that abuse is occurring, that you report it. And that takes me to the first handout, which is this rather colorful, some would say garish, poster. The purpose of it being to emphasize the importance of reporting. And it's on a little heavier paper so that it can be utilized as a poster. And you can post it in important areas where it can be seen by both staff and clients, so that they know of their one obligation and right to report abuse and the necessary information regarding reporting the abuse. The most important information on this sheet is the hotline number 1-800-426-9009. It's a 24-hour hotline. It is manned by staff during regular business hours and non-business hours. It's staffed by a vendor who we've trained to handle these kinds of calls, and of course our staff is on 24-hour beeper alert. So if anything, anytime you suspect that abuse is occurring, don't hesitate to call us. Even if you're not sure whether it falls under our jurisdiction or not. And I want to stress that, because over the years, I've been with the Commission now 7 years, but over the years what has happened and what has transpired regarding our abuse hotline is that it has become a clearinghouse for all kinds of complaints. Because even if it doesn't fall under the technical jurisdiction of our statute, we are mandated by statute to refer the complaint to the appropriate authority. And so that is done within 24 hours of receiving the complaint. So if you want action taken on any complaint, phone it in, because it will, if we don't handle it, it will be sent directly to the agency, DMH, which has jurisdiction over the matter to resolve the matter. The next bit of handout is this two-sided sheet. It summarizes what the Commission is. It summarizes, it gives you a thumbnail sketch of our State Police Detective Unit. For the past year and a few months, we've had the State Police Detective Unit on location. It is a statutory mandate that we have at least 5 state police officers assigned to the Commission. They screen every complaint that we receive, whether we have jurisdiction over it or not, and they're screening those cases for criminal activity and for criminal investigation. They not only screen, but they also conduct criminal investigations, and they assign criminal investigations to be conducted by law enforcement and the detective units assigned to the DA's offices in the state. Since the unit has been in the existence, as I said, for the last about 14 months. They have conducted in excess of 400 investigations, have resulted in approximately 40 arrests, and those arrests are now coming into trial and prosecution, and out of that 40 we are continually hearing about more convictions, but we have upwards of 10 to 15 convictions based on those 40 arrests. Considering that prior to the last 14 months the number was 0, I think that's a significant increase for a 1 year of operation. There's some self-serving and touting of what we do on the bottom of the sheet, and then at the top of the sheet it explains what the process is, and most probably from your perspective, the middle part of the second page, or the back page, is really important stuff. It talks about the indicators of possible physical abuse, sexual abuse, emotional abuse, and possible neglect. And I'd just like to take a minute to go over them very briefly with you. The indicators of possible physical abuse are puncture wounds, bruises on several different surface areas, bruises in various stages of healing, multiple bruises or bruises forming patterns or clusters, human bite marks, fracture to ribs, skull, arms, and leg bones, unexplained internal injuries, bilateral bruises. And by bilateral bruises, I'm going to leave the podium for a minute. By bilateral bruises, what we mean are parallel bruises. Essentially what that means is if somebody were to violently shake somebody, as I am, would you stand up so that they can see? I'm embarrassing this poor woman. That if I were to shake her violently, I would take her in a bilateral position and do this. You'll notice the position of my thumb in the front, and you'll notice the position of my hand in the back of her arms. So if you see marks the size of a quarter or a nickel in the front, and corresponding marks the size of pennies or a dime in the back, you can anticipate or suspect that somebody violently shook her. There's also burns shaped like an object, such as an iron or a cigarette, especially on the soles of the feet, palms, back, or buttocks. And I'll give you an example for the back. We had a case in which an individual was pressed against a radiator when it was on, and he was burned in the back. So the lines of the burns were parallel. And you could tell that it was intentionally done because where he was living, none of the radiators were at shoulder height on the wall. They were all low radiators on the floor. So he was obviously sitting on the floor, and someone had to have held him against the radiator, because otherwise the natural reaction would have been to leave that area immediately, to release the pressure if he was doing it voluntarily. Indicators of possible sexual abuse are torn or stained clothing and or bedding, pregnancy, vaginal or rectal bleeding, sexually transmitted diseases or vaginal infections. I'm going to point out two things about sexual abuse. When you're talking about a sexual abuse situation, you're also talking about a criminal situation or potentially criminal situation. There are two things that are imperative in these kinds of situations. One, you must preserve the evidence as it exists at the time of the occurrence or discovery. Don't change the victim's clothing. Don't bathe the victim. Don't make them look nice for the police interview. Leave them exactly as they are. You don't know how many times well-meaning and well-motivated staff clean up the site of the sexual abuse situation, and they're destroying evidence. They clean up the victim, they destroy physical evidence. And in many of these instances, that's the only physical evidence that the investigator is going to have, is what can be retrieved from the victim's clothing and or body. Usually in these situations, there are not any witnesses to the sexual assault. So the only evidence to link victim to aggressor or to abuser is what physical evidence can be retrieved either from the clothing, bedding, and/or victim's body. So just leave it as is until the investigators arrive. Indicators of possible emotional abuse are increased anxiety, fearfulness of others, depression, the client or victim appears withdrawn, lowered confidence levels, shame, lowered self-esteem, changes in the individual's ability to function. Emotional abuse is very difficult to detect unless you are very cognizant and very much aware of the way in which your clientele responds to the emotional situation. The best suggestion that I can make is get to know your clients very well. You have a wide range of reactions. You can have people who react emotionally very violently. They may be, in fact, eruptive in their emotional reaction. It may be very quick and short-lived. It may be at a minimal level but long-lived, or it may be almost non-detectable, such as just looking down at the ground rather than looking at you in the face when they're talking. So the only way that you can distinguish between what their normal reactive reaction would be and what an abusive reaction would be is based on your personal knowledge of that client and how they emotionally react. Indicators of possible neglect include a lack of clothing or improperly clothed for weather conditions, cucurbitae or bed sores or skin rashes, dehydration, malnutrition, a failure to provide eyeglasses, dentures, wheelchair, hearing aid, any kind of assistance that may be needed, medication mismanagement, a lack of access to a telephone, and architectural barriers. Mandated recorders, and I'll get to this under the training, but you should be aware of the fact that there are two kinds of recorders under our statute, mandated and non-mandated. Non-mandated is everybody in the world who isn't a mandated recorder. And mandated recorders, if you look at the list of mandated recorders that's listed there next to each bullet, if you go over them all, you will note that generally speaking, they are identified because of what they do for a living, it is more likely than not that they are going to come across a disabled individual, whether that person is mentally retarded, mentally ill, or physically disabled. Okay. The next one is the training outline, and I'll just ask you to put that aside for a minute. The next sheet is this two-sided sheet. One of the missions of the Commission is not only the investigation of abuse, but also the prevention of abuse. And in furtherance of that goal, we have published and have developed training modules for teaching people how to avoid abuse, how to prevent it from even occurring. Abuse prevention strategy, this is a very short synopsis of it, and it's divided by prevention strategies that can be used by individuals or mandated recorders, abuse prevention strategies that can be used by agencies, and elements of a plan to prevent abuse and neglect. So if you go back to the top of the page, regarding individual mandated recorders, well, by attending this training, you're fulfilling the first one, is to educate yourself about 19C and the reporting requirements. The second one is to gain a knowledge of the symptoms or the manifestations of abuse and neglect. The third one is to establish trusting relationships with self-advocates in your care. And the third one is for immediate protective service interventions to be implemented, including referrals to law enforcement if appropriate. Abuse prevention strategies for agencies. One is to develop an agency philosophy which stresses that prevention begins with agency commitment to become abuse-free, a zero tolerance for abuse. And we have worked very closely with some agencies statewide to develop this kind of policy. And if you or your agency are interested in developing that kind of policy, jot this woman's name down. Her name is Susan Love, L-O-V-E. She's a Director of Outreach and Prevention. Telephone number is 727-6465. Just ask for Susan, and she'll help you. She'll come out, she'll meet with you, she'll provide you what resources we have available. We maintain a rather extensive abuse prevention library, and she will provide you whatever resources we have that are available and tailor-make a program for you. 617-727-6465, Susan Love. There has to be an agency commitment to carefully articulate a plan that will achieve zero tolerance of abuse. Someone in the organization has to be given the responsibility to prevent abuse, and all staff, consumers, and the families of the consumers must be made aware of the commitment and of the plan. And the agency must continually evaluate the plan and progress that it makes in achieving its goal of zero tolerance of abuse. The plan needs to be an organic document. It needs to constantly be reevaluated and updated to adjust for the changes in clientele, changes in staff, to work out the glitches of the original plan. The elements of a plan to prevent abuse or neglect include the assessment of past experiences. What are the agency's areas of vulnerability? And I'll give you some examples of that. Let us say that if you do, and we can do this for you too, we also provide a service to providers, and that is we can do a survey over a number of years of the number of abuse complaints that we have received regarding that particular agency. In order to get a survey, you need to make a request in writing, and you need to make it to me at the address on all of these pieces of paper at the Commission, which is 50 Ross Way, Quincy. What that will do, it is a starting point, because if you examine one of these surveys, what you find out is you can identify which programs of an agency are more prone to be abusive than not. And if you do an examination of what the underlying reasons for that are, they could be large turnovers in staff. They could be ill-prepared staff. It could be ill-trained staff. It really requires the agency to do a complete and thorough internal examination of their hiring practices, their training practices, and their staffing practices, as well as their protocol practices. Excuse me. And so consequently, a good starting point is to request for one of these vendor surveys, because they can provide you that kind of overall lay of the land kind of picture, which can be an initiating starting point for the self-examination. Evaluation of recruitment strategies, the interview practices, references, CORI, and SDIP checks. This is another service which we provide to agencies. Is that we can provide you a check on whether a prospective or current employee has had any complaints of abuse lodged against them. The requirement, however, is that you must have a signed release by that prospective employee or current employee to release that information to you. In order to sign up for the program, it's very simple. Excuse me. All you have to do is write me a letter at the Commission's business office in Quincy and say that you want to participate in the employee check program. I will send you all the necessary information and tell you what the parameters are, and I will also tell you what we can provide and how and what information we would provide to you. This is important because what we have found is that people who are abusers, they may be fired from one provider and they will go to work for another provider. And they become abusive there. And they get fired and then they go to another provider. And so the only way that you would have any awareness of whether there are any preceding complaints about a particular prospective employee is through the utilization of our employee check program. Prevention training for all staff. This is critical. We have developed training modules for self-identification of stress when a person is under stress. Stress is the major factor in causation of abuse. I would say in 85% of the cases, abuse occurs not because the person is perverted, but because the person just loses it at that particular moment and reacts in a completely inappropriate fashion vis-a-vis the client or consumer. It's very important, therefore, that you as caretakers be aware of the fact that you are in very pressurized situations most of the time, and that you need to develop ways to deal with that pressure. In fact, none of us are immune from bringing the pressures of our private life to our work life. And so consequently, when you are working in a more pressurized environment, it exacerbates the impact that private life pressures have on the work life pressures. And so it's very important to be trained to self-identify what those pressures are and how to cope with them and how to identify them and be able to say, I need a time out at this point. Somebody else needs to take care of this situation because I can't trust the way I'm going to react. And there's nothing wrong with saying that. That's simply a recognition of the fact that you're human in a job which demands you to be more than human in most instances. There should be a review of supervisory practices, what needs to change to support prevention. Clients need to be inculcated in what we call the know, go, and tell protocol. Say no to the abuse, go and tell somebody immediately. Report it immediately. Don't be ashamed of it. There need to be consequences for the perpetrator. You need to support the victim. And there needs to be internal and external communication. Communication here is a key. Everybody needs to be on the same page. You can't feel like, oh, I can't report this because they may think I'm a turncoat or a snitch or something like that. There needs to be an acceptance of the fact that abuse is going to occur and that when it occurs, everybody's on the same page and feels that and has decided that it needs to be immediately dealt with. And consumers need to be empowered to resist abuse. I won't spend all the time going over this, but you need to train and educate your consumers to know that it's not their fault if they are abused. That in fact, they need to speak up and need to report it and need to have the confidence to know that something is going to be done about it, that they're going to be supported. The other two documents are just form documents. We provide them to you because what they are duplication of our report forms. When you call the hotline, the person who is sitting at the hotline is sitting in front of a computer screen. This is a duplication of what's on the screen. And the screen prompts the information required to be taken over the phone. We give this to you so that you can anticipate what information will be required of you when you report, and so that you will be able to give as much as a complete report as possible. The two forms are the first one is for abuse, reporting of abuse. The other is reporting of deaths. Under a section in our statute, if the client dies while they're being serviced either by a state institution or by a state contract provider, that death needs to be reported to us regardless of the cause of death. And then we make a determination as to whether we think it's likely that the cause of death was suspicious. And if it is, then we would mount an investigation into that death. The last sheet is simply an evaluation form, which I'd ask you to fill out at the end and leave it on the back table. It tells us how good or bad I did today. I'll turn to the training outline, and I'll try to be as brief as possible. Mass General Laws, Chapter 19C, is our enabling statute. It established the Commission in 1987 as an independent investigatory agency with oversight over the investigations of abuse, which may be conducted by either DMR, DMH, or MRC for the Commission. The Commission historically has had a very limited investigative staff. We currently have 6 or 7 investigators. And the number of complaints that we receive are approximately 4,500 a year. Out of that, we screen in to be investigated about a third of them. So you're talking in excess of 1,200 investigations a year. No way in hell can 7 investigators conduct 1,200 investigations in 1 year. And so consequently, the statute allows us to farm out, if you will, investigations to the agencies which have jurisdiction over that particular victim because of the disability. In this case, it would be DMH, because we're talking about clients who are suffering from mental illness. Those investigations, as I said, are conducted under our oversight. The report is submitted to the Commission and is subject to our acceptance. We also have the authority to reinvestigate cases when we think the initial investigation is not up to par or that something has been missed. Because our investigations are controlled by statute, everything we do in the Commission is controlled by the statute. And so, therefore, in order to understand what we do and how the process operates and how your complaints of abuse are handled, it's necessary for you to understand some very basic definitions. Number one, how is a disabled person defined under the statute? There are 3 criteria that a person must meet in order to be disabled under the statute. Number one, they have to be between the ages of 18 and 59. If they're younger than 18, they fall under the jurisdiction of DSS because they're still a child. If they're over 59, they are considered an elder, an appellation which I hate more and more, the closer and closer I get to that age. And that would fall under the Executive Office of Elder Affairs. So we take care of people between the ages of 18 and 59. The second criteria, and this is the most commonsensical element of the criteria, is that they have to be disabled. They have to be either mentally retarded, suffering from a mental illness, or be otherwise physically disabled. The third criteria is one of dependence, and that is the kicker here. It's the most unusual element, and that is that because of the disability, the person is either partially or wholly dependent upon another for the provision of a daily living need. So that means that you could have somebody who is completely dependent 24-hour a day on caretakers, or it could mean that somebody only receives support for medication, for the taking of medications, or for the keeping of their financial records, or maintaining their household. So it can run the gamut, but the important thing is that because of the disability, that's the reason why this dependency is required. And I'll give you an example. I do not suffer from a disability as would be defined under the statute. However, if I went into the hospital and had an operation, I become completely dependent on the staff for my provision of daily living, right? Great. I would still not be a disabled person under this statute. Why? Because I don't have an underlying disability. I'm not either mentally retarded, mentally ill, or otherwise physically disabled. And as a result of that, illness in and of itself, or medical care in and of itself, does not constitute a disability. Okay? The next thing is the definition of abuse. Abuse is a serious physical or emotional injury to a disabled person which results from the act or omission of the caretaker, including unconsented to sexual activity. What do we mean then by the result of the act or omission of the caretaker. The act is any intentional act, and I'll give you some examples, and I'm going to leave the microphone. If I slap this woman across the face, that's an intentional act. It's irrelevant whether I hurt her or not. The act, the intended act, is the hitting. Okay? We get a lot of complaints. We get a lot of reporters who say, well, I saw somebody hit somebody, but I know they didn't mean to hurt them, so it can't be abuse. Well, that's not the point. The point is that they hit them. That's enough. It's not a question of whether they hurt them or not. Okay? The other thing is you could have a negligent act. Let's say that you have a client that is behaving, and you have to physically restrain them. When you're trained to physically restrain somebody, you're told to try to pull them into an area that's open and that is not cluttered with furniture or whatever. True? Because there'll be flailing limbs all over the place, and it's bound that either you or the client is going to get hurt. Well, let us say that you attempt to restrain somebody, and you are in a confined area, and they hit, the client's head hits the edge of a table as you take them down. That could possibly be negligent act. Okay? Could be. It should be reported. It should be looked into. There should be some way of looking at that to see whether that could be avoided or not, whether that situation could have been avoided. If in restraining the client you did everything you possibly could to avoid injury to the client. Okay? You could also have an act which is reckless. And I'll give you an example of this. Let's say that you have a medical appointment and you have to drive the client to the doctor and you're running late. So you put the client in the car, you strap him in the car, you get behind the car, you strap yourself into the car, you put your foot on the accelerator and you go 90 miles an hour. You do not stop for any red lights. You do not stop for any pedestrians, especially those young mothers with baby carriages. You go 90 miles an hour. You arrive at the doctor's. You put your foot on the brake. You look at your watch. 5 minutes early. You are happy that you're there on time. You look at the client, and the client is frozen in a state of catatonic fear. That's a reckless act. Why? Because you intended to do good. You intended to get them to the doctor on time. However, the way in which you did it was for a total disregard of their welfare. That's a reckless act. So you can have an intentional act, smack. You can have a negligent act, take down, accidentally harm someone. Or you can have a reckless act. Do something well-meaning, but do it in such a way that the person is harmed. Okay? Omission. Omission under the statute is the same as neglect. It's the failure to do that which ought to be done. Failure to hydrate, failure to feed, failure to properly clothe. Those are the most obvious examples. Serious physical injury. Serious physical injury includes, but is not limited to, death, which is the ultimate injury, brain damage, disfigurement, any non-trivial injury including, but not limited to, fracture of a bone, skin bruising, intramuscular injury, puncture wound, abrasion, laceration, burn, bleeding, impairment of a bodily system or organ, including the skin, excessive bed sores or similar condition, or the harmful symptoms resulting from the use of medications or chemicals without informed consent or authorization. Malnutrition or dehydration, a pattern of unconsented touchings or unconsented sexual touchings, sexual penetration, or sexual exploitation. I'm just going to take sexual exploitation to clarify. There are cases in our records which indicate that staff seduce clients for their own sexual gratification. Not for the client's gratification, but staff's gratification. And I'll give you an example. Example of a nurse who did all these special favors for this particular client that she was attracted to. And these favors were contrary to the rules, so that the client knew that. He knew that if she didn't do them, he would not have these favors done for him. These favors include things like cigarette breaks and, at unscheduled times, extra cigarettes, little things. They weren't major. Getting him the issue of Playboy magazine on time or whatever. It was just that kind of a thing. Eventually, they had a sexual encounter. Afterwards, the client felt guilty, responsible, and said to the nurse that he didn't want to do it anymore. And she insisted. She told him that if he didn't do it, all those favors would stop. But he continued until he was released, and then when he was released, he told her that he didn't want to do it, and he reported it to us because she wouldn't leave him alone. That's sexual exploitation. And that's despite the fact that there are rules, regulations, there are department regulations which prohibit that kind of conduct. And consequently, you need to be aware of the fact that that kind of thing actually does exist. It does happen. And it is horrific, the impact that those kinds of situations have on clients, because they blame themselves for the situation for occurring, and then also feel guilty about giving into the situation. Yes, ma'am.
What happens if another client they inappropriate or unwelcome sexual advancing to another client when the staff has taken every precaution to see that nothing happens?
I think what needs to happen is that obviously the client has to feel comfortable to report it. And I think what the obligation of the agency is to reevaluate what precautions they've taken and to see what else they can do. Obviously those situations are the trickiest because you're dealing with human rights on both sides of the issue. I mean, in terms of, you can't put the perpetrator in a locked room. You can't. I mean, so in isolating the perpetrator, it becomes very important to understand that their human rights can't be violated either. And that in protecting the victim, their human rights can't be violated either. So it's not the easiest situation, but I think that's what my suggestions would be. I don't have a bad answer for you. I think it is a judgmental question which is really directed by the particular facts of that particular situation and what has been done previously and what possibly could have been done. And a close examination of why this, if certain procedures have been implemented, why did they fail? Why didn't they work?
Is that a reportable act to your commission?
It could be. It could be omission on the part of the caretakers. If they fail to do that, which ought to have been done in order to protect the victim in that case. So that would require them to have prior knowledge. In your example, they had prior knowledge. It's just simply a question of whether they implemented the protocols that they had developed, their preventive protocols that they had developed, and whether they were consistently applied and followed. So the fact that they may not have been is a potential for abuse by omission. Serious emotional injury includes, but is not limited to, a state of anxiety, fear, depression, withdrawal, or the development of post-traumatic syndrome. The important thing under our statute is that there must be some physical manifestation of the emotional upset. It could be minor. This is where I was talking about understanding and appreciating the way in which your clientele emotes and responds to emotional situations, because they're very idiosyncratic. And so it could be very minor, it could be very major. I mean, you could have a client who might throw a TV out a window and to manifest their emotional upset. At the other end of the spectrum, you could very well have somebody who simply becomes completely withdrawn and disengages completely. And you would say, well, she's having a quiet day today. But if you really knew her, you would know that she's upset, and that's the way she reacts when she's upset. So there needs to be some prodding to find out why she's upset. That needs to be addressed. A caretaker, we've already defined it, although I haven't identified it. It's the person upon whom the disabled person relies for assistance in the provision of a daily living need. I've talked about mandated reporters and non-mandated reporters. You should know that mandated reporters are fully protected under the statute. There is no criminal or civil liability for reporting. In other words, if you report something and it subsequently is unsubstantiated, the alleged perpetrator can't come back and sue you for defamation of character or anything like that. You're fully protected under the statute. If you fail to report, you are subject to a $1,000 fine, and I warn you that I have a bill in the Senate that's passed the House and gone to the Senate to increase that fine to $5,000. Yes?
Can an agency make it that fine they're not keeping anybody from reporting to the HPC of alleged abuse, but do they have to say that you have to inform your supervisor?
No. In fact, I would consider that contrary to the law. They can have a parallel system whereby there's internal notification, but that internal notification should not preclude you from reporting. The reliability under 19C is a liability that goes to you personally. It's a liability to you as an individual, so that you are liable for the $1,000 fine or the amount of the fine. Your employer wouldn't be. So consequently, since it's personal liability, I don't think that there should be any protocol which precludes you or prevents you or which would inhibit you from reporting. And if the intent of that internal mechanism is to inhibit you from reporting, then I would consider that illegal. And contrary to the statute.
Not informing the supervisor that you reported.
Yeah, I think the most that they could ask you to do is to insist that you report the incident internally as well. In other words, apart from any responsibility that you have under the statute. It's between you and the commission as to whether you've reported it. If we get multiple reports, in other words, your supervisor would be a mandated reporter as well. So if you reported to us and you reported internally that it occurred, just that the event occurred, not that you reported, but just that you occurred, the supervisor then would have a liability to report to us as well. And we're completely computerized agencies, so that multiple reports are filtered out by the computer automatically. And so consequently, the requirement that you notify them that you reported, I would consider perhaps an inhibition. If anything, it would be have a chilling effect on the obligation to report, because you might be afraid of retaliation. You might be afraid of disciplinary action. You might be afraid of some kind of personnel action being taken if your supervisor or management were aware of the fact that you had reported this to the commission. The identity of a reporter is sacrosanct under our regulations. We don't even release them to the service providing agency unless that agency is conducting the investigation. And the restriction on the service providing agency is that only the investigative unit is aware of the reporter, because they are the prime source of initial information in the investigation. But beyond that, the name is blacked out, and it's blacked out internally as well. I mean, I've had arguments with lawyers and judges about this, and I've won every time, because the law is quite clear. It's very specific. We have an opinion from the supervisor of public records that indicates that our records are exempt from the public records statute, that they do not fall under 66, but they are considered private. The information contained in them is considered private to the individuals about whom it refers. as I said, if you talk about mandated reporters and you identify them, they are identified as a category because of what they do for a living. They would be more than likely to come in contact with a disabled person. You have, besides direct care staff, you have police, you have school officials, teachers, social workers, medical personnel, etc. Retaliation against reporters. Under Section 11 of the statute, retaliation against anyone who cooperates or provides information in an investigation or report of abuse to the Commission is retaliation under the statute, and consequently is a crime under the statute. And it's and we pursue those cases. If you ever become the subject or think you've become the subject of retaliation, you should report that to the Commission. We process those complaints. They have to be made in writing. We process those complaints. We determine whether there is sufficient jurisdiction. If we determine there is, then we conduct an investigation. In those cases in which the retaliation is substantiated, we refer them for criminal prosecution because they are a crime. Since the state police have come on board with the Commission, we've had more success in getting DAs interested in prosecuting these cases. In addition to which, in the past, what we've done is we've used substantiated cases and the potential for a criminal complaint, the issuance of a criminal complaint, as leverage to help the victim of retaliation negotiate a civil settlement with the retaliator. It's usually back pay, that kind of thing. And then we drop the complaint, the criminal complaint. You should be aware of how the system operates. Essentially, the way the system operates is the call comes into the hotline. The hotline person takes down all the information. It's then handed over to two individuals in senior management to do the screening to determine whether we have jurisdiction or not. If we have jurisdiction, it is screened in for investigation and assigned for investigation within 24 hours. If it's screened out, it's then sent to the appropriate agency for action to be taken under their regulatory authority or licensing authority. Once it's been assigned to the investigator is given 10 calendar days to complete the field investigation and another 20 days to complete the writing of the report. It's supposed to take place in 30 days. It doesn't. It takes place between 45 and 60 days. It's simply a question of numbers, too many cases and not enough people doing it. Once the case is investigated, if it's unsubstantiated, that's the end of the case. If it's substantiated, however, there are two things which occur. Number one is investigators in substantiated cases are statutorily required to make recommendations to make sure that this situation never occurs again. Those recommendations are converted into a protective service plan. Protective service plan identifies what needs to be done, the date by which it needs to be done, and the person responsible. And we oversee the implementation of the protective service plan. So it's very possible for a case to stay open for several months until all elements of the protective service plan are implemented. The second thing in a substantiated case is once the case is approved by statute, before we issue the report publicly, we must notify the alleged abuser that a substantiated case has been made against them and give them the right to respond. There's one thing I want to stress here, and that is that we only conduct investigations, we only make recommendations, we don't take any actions that would impact on the parties in the investigation, and so consequently our appeals process is non-adjudicatory in nature. There's no hearing, it's just done in writing. It's done by the legal department who has no vested interest in the case. Our perspective is we're defending the statute in the investigation, so if the investigation needs to be overturned because it doesn't meet the requirements of the statute, it's overturned. If it meets the requirements of the statute, it's substantiated and upheld. That's the bulk of my presentation. I'm getting my hand from Peter. I've spoken too long. I would ask you to hold your questions until Peter's finished, and then we'll take all the questions at one time. Thank you very much.
Thanks, Ralph. And I can be quick and cover the basics of the DMH investigations process right now. In January of 1998, new investigations regulations were implemented by the department. And for anyone who's interested in the CMR numbers 104, CMR 32. The goals of these new regulations are to provide for swift resolution of complaints, accurate reporting, investigation and resolution of complaints of a very serious nature, and to allow for the resolution of the majority of complaints at the program level. The major changes in the complaints are the scope of the investigations regs, or the scope. The jurisdiction used to just apply to programs that DMH operated or contracted for. Now, since 1/1/98, any program that is licensed, contracted for, or operated by the Department of Mental Health falls under these investigations regulations. So that means that anyone in a licensed facility, contracted program with the Department of Mental Health, or a program that we operate, anyone who witnesses or believes they have been a victim of something, an incident that is dangerous, illegal, or inhumane, may file a complaint with the Department of Mental Health. Dangerous is fairly obvious. If it's a danger to someone, if it's a situation or incident that places someone in danger. Illegal, anything in violation of federal, state, or local law, regulation, policy, or case law. And inhumane is without regard to client dignity. Something, an incident occurs which is without client dignity. A complaint can be filed. The person who would receive the complaint initially would be the person in charge of the program, and that is defined, the person in charge is defined under the regulations as the person having day-to-day responsibility for management and operations of the program or facility, or his or her designee. And this is envisioned to be someone with sufficient authority and resources to promptly address a complaint or redress a problem. The regulations identify 7 major categories of incidents which are mandated to go to full formal investigation. And those categories are: if a medical legal death occurs, sexual assault or abuse, physical assault or abuse, attempted suicide resulting in serious physical injury, where a felony has been committed, restraint or seclusion practices not in accordance with department regulations resulting in serious physical injury, or a 7th category where if the person in charge of the program believes that the incident is the incident or condition is of sufficient complexity or seriousness as to require a full investigation. So the complaint would be filed. If it falls into one of these 7 categories, it automatically is referred to the Office of Investigations for formal investigation within, and the investigation would be completed within 30 business days. We've had, I believe, 411 investigations assigned through this mechanism in 1998. The average time of completion was around 35 business days for completion of the investigation. If the incident or complaint does not fall into these major categories, it should be resolved within 10 business days at the program level. The person in charge would assign someone or conduct fact-finding on their own. Fact-finding is defined to include, and is really meant to allow the complainant to tell their story. And they should be the first person anyone engaging in fact-finding under these regulations should talk to. The complainant should be allowed to tell their story. The persons complained of should be interviewed. Other relevant witnesses should be interviewed, and any relevant documentation should be reviewed. At the end of a 10 business day period, for a minor investigation or a below-the-line investigation is the term that we use, a decision letter should be made available to the parties to the complaint, and the decision, if it is not to the satisfaction of the complainant, it can be appealed away from the person in charge to the area director, and then if not resolved at that level, to the deputy commissioner. If a 30-day investigation isn't resolved to the satisfaction of the complainant, it can be appealed from the area director, who would receive the 30-day report, to the deputy commissioner, and then to the commissioner of mental health. The right of appeal is only in the complainant. A person complained of cannot appeal a decision letter, but can ask for reconsideration. And reconsideration is based on whether or not facts were considered or were available to be considered by the investigator during the investigation. And if they weren't available and it should have been considered or should be considered to change the outcome in the decision letter, that can be a ground for reconsideration. Or if they were available and not considered properly, that can be a grounds for reconsideration. But no right of appeal exists under these regulations in anyone other than the person filing the complaint. Again, the fact-finding, good faith interviews, good faith efforts should be made to interview each witness. If witnesses aren't available, it should be documented. The attempts to interview the witnesses should be documented and kept in a case file. All investigations, interviews, all materials should be kept in a case file by the persons conducting the investigation. The average time that we've had for below-the-line complaints has been roughly 14 business days. So we're in the ballpark of complying with the regulatory framework, and we're doing much better than we did under the previous 5-day framework, where we weren't even near the completion rate or the regulatory guidelines. I know we're close to the end of the time period. If there are any other questions that you have about the DMH format, I have some copies of the regulations, and if we run out of those, I'd be glad to take your address and mail you copies if we run out. But I would like to, if you're in a situation, I'll just leave you with this and then we can get to your questions. If you're in a situation where you got to make the first call, and Ralph talked about, and the question came from the audience, should I be required to call your supervisor? No. Confidentiality of your call to DPDC should be maintained, and you shouldn't be required to report to your supervisor first. Also, under our regulations, if you're being interviewed as a witness, you are allowed to have someone with you of your own choice as a witness to the interview. But you are not mandated to have or allow, or you can't be forced to have your employer or supervisor there with you when you're being interviewed. The interview should be in an environment that's free of coercion, and you should be allowed to say what you have to say to the investigator. So during the course of the investigation, if you choose, you or any witness that is being interviewed has the right to have who they want present during the interview, and has the right to exclude who they want from the interview as well. Why don't we take questions at this point? Yes, ma'am.
So you spoke of being able to check on prospective employees to see if they've had any complaints filed through your agency. Is that simply complaints that were filed or complaints that were filed to be qualified?
No, essentially what we'll tell you is whether any complaints were filed, whether they were screened in or not. We'll give you a summary of the allegation. If they have been investigated, we will tell you whether they were unsubstantiated or substantiated. And we'll give you a very short synopsis of the reasons why. And we'll also tell you that if you want a full copy of the report, you can get a redacted copy of the report. But we need to know that as a separate response from you.
It would be a synopsis of the whole process and not just a one-liner?
No, it wouldn't be
You
just,
had like six.
the only time you would get a one-liner from us is if we have no records. It says we have no records as of this date on this individual. That's the one line.
And this one, who can request that?
Any agency can. The only requirement is that they have to submit to us a signed release by that particular employee or prospective employee. What we recommend is that you make it part of your normal process of hiring. You contact us for the forms, we send you the forms, and you just make it one more sheet of paper that they have to sign if they're interested in the
So
job.
this would be in addition to a core check?
Yes.
I recommend that you-
Yeah.
Yes, ma'am.
It's very clear to me on emotional abuse, if a staff person went off on a rage, verbal rage, or attacked the client verbally, that would be a reportable incident. But what happens when a staff person just goes off when they shouldn't and makes a real rash statement, turns around and walks away? Should that be filed under human rights, or just take the person aside and talk to them?
It really depends on the situation. It's a judgment call that you have to make. In looking at it from the DPPC perspective, you got to ask yourself: was there abuse? Was there omission? And did an injury result from this as well? You have to look at that aspect. And in some instances, that could result in omission, or even if it doesn't meet the definition of abuse or intentional abuse. It could be an omission act if there's a history of some kind of activity like that on the part of the employee, and the employer doesn't do anything about it. From our perspective, you would look at: was this dangerous? Was this illegal? Was this inhumane without regard to client dignity? And then you would have to make your decision on whether or not to file a complaint. And then when you look at that, the person in charge, if the complaint is filed with DMH, the person in charge would say, does this fall within one of those 7 categories, or can I handle it through a 10-day category? I think one of the things, when you're dealing with it through our regulation, one of the things you have to look at is: what is the concern of the client or the complainant? How can we resolve it satisfactorily?
The other thing I would say is, when in doubt, report it. Because we're the experts. I mean, we're the ones who deal with these distinctions that we've drawn for you today on an everyday basis. We expect an awful lot of you to understand or to develop a facility with these kinds of distinctions. And I take a more commonsensical approach towards this. If you think something has happened that shouldn't have happened, report it. If it doesn't fall under our jurisdiction, we'll send it to DMH. And DMH will look at it and decide how they're going to handle it, whether it's below the line or above the line. And either way, the problem needs to be looked at. It needs to be resolved.
I agree. I think you're much better off reporting it and dealing with the consequences of it that way. And then when you report things and see and observe how they're handled and disposed of, then you'll get a better idea of what's reportable and what's not, I think. Hopefully we'll be consistent in response. But I think you're in a program as an administrator or as a worker, you're in better ground reporting. Yes, sir.
Are you ever going to change your investigational procedure?
In what way?
Well, like you give it to the agency maybe that has a problem with, like you say, you don't have enough investigators?
Well, that's really up to the legislature, because it's a dollar and cents issue.
And what do you people, what is the Disabled Persons Protection Department doing, the commission doing about it?
Well, we're currently discussing with the other agencies our ability to conduct internal investigations.
Because it's a great idea, but it doesn't work. Nobody's going to report on themselves when the abuse goes on. It's pretty sad. It's worse. I think it's more emotional abuse than anything else. It's allowed by you people, allowed by DMH or whatever agency or service provider. It's pretty sad that we spend all this money on this. And I've heard lots of times that it's a waste of time to do anything. Because like you say, you transfer it over to the one's doing the abusing or whatever else, pretty much, basically, so. Actually, they're not going to substantiate that they have a problem.
Respectfully, sir, I disagree because we have a higher rate of substantiation than DPPC does in handling cases on our clients. Not to say that they don't substantiate where they should or where they shouldn't, but I think that this administration and this commissioner take the report of abuse very seriously. We've worked hard, and there is an ongoing dialogue between DPPC, DMH, DMR, and other HHS agencies to better define where they can work together, where DPPC should investigate independently, and where we should work cooperatively. So I can readily attest to the past where things haven't been done right, but I can also attest to all the efforts that have been made to improve the situation both within DMH and within DPPC.
Well, sorry, I can attest to the fact that it wasn't done. I was left myself with no food, no medication, no money, no this twice by DMH. No, this is just a couple of years ago. I didn't say it was correct.
I didn't say it's been corrected, but we're working.
Yeah, but it's, and then they don't substantiate any abuse, and it was abused by the provider and also by case manager naturally. They would say that when you're ongoing.
What's key to remember too is any case that's being investigated, but it's being investigated by DMR or DMH or MRC, DPPC is oversight authority, so they're monitoring all the investigation. And as well, any reporter can request that DPPC conduct the investigation instead of.
Yeah, and I requested that, so don't try to tell me what happened, because I lived through it.
When you requested it, did DPPC conduct the investigation?
No, they didn't. I was on my own against everybody, from whom I had to fight DPPC, Department of Mental Health, Tri-City Services, whoever else.
Well, I'm glad that you're sharing your experience with us, because it's important that we learn from.
Well, they know, it's not just my experience, I've heard it quite often. I'm on the Human Rights Committee now, and I hear it quite often. It sounds good, but until it's actually put in practice, taught, it's cheap. It's pretty sad when it's allowed to happen.
Just, looking at these categories, I have a couple questions. One is, when you have, say, a client hit another client, okay, at what point does that become physical abuse and something that should be reported if you think that there is not, in other words, if there's no damage done, my tendency would be to not think that this is a reportable incident. If the staff hit a client in the same way, I would think that it's a reportable incident. So I just wanted some clarification there. And also on the illegal thing, if a client does something which is illegal, say for example, you know that a client is smoking marijuana, this isn't what we're talking about, or is it? So, just asking.
Okay, I think it's very important to make a distinction between what is a reportable incident and what is a complaint. Okay? Critical incident reporting within DMH, what you described, I think, physical abuse client on client, I would report that as a critical incident. Yeah, whether I would probably put it in a category 2, within 5 days, unless there's serious physical injury, then it would become category 1. If there's serious injury in the physical abuse, I would see it as a complaint. If there's not serious injury, but it's been repetitive, if it's happened before, within the program, and you've had repeat client-on-client, small-time stuff, but it's still, I think it reaches the threshold of inhumane and may be worthy of reporting. I think under 19C it's worthy of reporting because it may reach omission, even if it doesn't involve a caretaker.
And the reason it would come under omission is if there is a history of this aggressive client being aggressive. And the incident occurred because the provider failed to take any measures to prevent it from happening again, that would be omission.
Yes, ma'am.
Just like the presentation where you said both supervisee and supervisor needed to make reports. If they are making a report collaboratively, and they both have the same information, do they both need to?
No, not if they're doing it collaborative. His example was one where my understanding was that the supervisee was the one who was making the report, and then being asked to tell his supervisor whether he had reported or not. Well, the only reason that would be acceptable to the commission for making that requirement would be so that there wasn't a duplication of reporting. And my point was that that's irrelevant. That argument is really irrelevant because duplication of reporting is encouraged by the commission. Because we can deal with the duplication of the reporting. So that it would seem to me that the only reason to make that requirement of notification to a supervisor that you had reported it would be to create a chilling effect, a possible chilling effect on supervisees reporting. Yes.
The thing is the issue was, the situation is that it wasn't even reported for the agency that supervisors worked for, it was a big program, but they saw when you made the example of, let's say, water size and left on the shoulders, and he didn't really think about telling the supervisor because the supervisor wasn't there for the day or whatever reason. It was just that he didn't see him that often. And the executive director of the other agency called the executive director of that agency, which ran down the way, who reported. And the supervisee all of a sudden was from a real good worker to all of a sudden felt weird, was getting like a cold shoulder all of a sudden from all whatever happened.
Which would just simply
And
indicate
he
that,
admitted, doing the report.
which would indicate that it did have a chilling effect. That the reporting to the supervisor, that the report was made by this particular individual, had a chilling effect on the relationship of that individual employee with his supervisor and or fellow workers.
And what we've done in those situations,
And they reported to that person too that, oh, didn't you remember you're supposed to say that? They told you in orientation, which knows what it was.
what we've done in situations where somebody's been in your, and what you're describing, where I'm afraid that their attitude towards me as an employee is going to change, and they've come through our investigations regular. We've told them, report this to DPPC so you get the anti-retaliation statute protection as well, so that if it's duly reported, there's an element of protection, there's an additional element of protection, and we utilize that in a number of occasions.
And I'm not saying the DPC would say,
No, I understand.
public.
Yeah, I understand what you're
Somehow
saying.
they find out, somehow they learn.
Especially in small programs, yeah, that's a
And
secret.
it happened way over 5 years ago, so deal. But the thing is, it can happen again to other people. And,
Sure.
No, I know.
Yeah. Yes, ma'am.
So if this report is substantiated, is there no retaliation?
Yes,
Even if the report is unsubstantiated,
it has no relation to the outcome of the investigation. The only requirement is that you participated in either the reporting of the complaint or in the investigation of the complaint. That's all that's required.
And if you complained, I mean, if you complained under our system, under our reg, and it's not substantiated and there was retaliation, that's grounds for another complaint because it's illegal. Retaliation is illegal.
Oh, you just need to send me a letter, request them, tell me where you want the forms sent, and I'll send them to you.
Yes.
How is the age cutoff at 59?
That's where Department of Elder Services jurisdiction kicks in at 16.
So somebody, if you know somebody's over 59, or something else.
Well, you can report it to us because we'll automatically, by statute, refer it to the Executive Office of Elder Affairs. But you're right. They have the direct jurisdiction, so you could call Elder Affairs. But
And you can report it to us, and we have no age cutoff. And we would be obligated, once learning, to let DPPC know as well. So if you're in a situation where you don't know the age, just report it, and we'll get you to the right place. Yeah. And if you only have one dime or 1/4, and you have to make the call to DPPC, because we cross-check.
Yes, sir. What would be an example of typical investigation, something that you find looking into? What are the
criteria?
What's the process that you guys go?
The criteria is a rather extensive one. The script for the criteria runs over 17 pages long. But in essence, what we're looking for is a physical manifestation of a physical injury, if we're talking about a physical injury case. Or we're talking about some physical manifestation of the emotional injury. There has to be some identified action by a caretaker, as defined under the statute. And there has to be a safety person, as defined under the statute. And in basis, that's what the basis for the entire criteria is. I mean, it's a rather elaborate and sophisticated analysis that the screeners go through. But essentially, that's what they're looking at. They're looking at all the options and all the alternatives of, do we have a disabled person? Do we have a caretaker? Do we have a physical or emotional injury, manifestation of a physical or emotional injury? And what's that result of an act or omission of the caretaker? And if we have those, in any kinds of their manifestations, they're really driven by the fact patterns and the variety of facts that don't limit. We would go jurisdiction.
And in ours is first thing, is it dangerous, illegal, or inhumane? Is this defined under the reg? And then if it meets one of those categories, the second level of screening is, does it fall into one of those 7 categories that requires a full-scale 30-day investigation? And if the answer is no, it goes to a 10-day process, and the fact-finding committee start. If the answer is yes, it's assigned to the Office of Investigations, given an investigator. A letter will be sent out to the party saying who the investigator is, what the date of the investigation's completion should be, and then the process begins. So it's a shorter inquiry that's really driven by the language of the rules. Yes, sir. A caretaker is a relative. It's still reportable under 19C.
A caretaker can be a relative, it can be a paid employee, it can be a volunteer. We have cases that we've screened in for investigation where you have neighbors who act as volunteers. We had one case where a neighbor acted voluntarily in dispensing medication and then didn't dispense the medication, and consequently the client decompensated. She was considered a caretaker. And so and didn't make any arrangements for future care. That's an omission by caretaker. It's failure to do that which ought to be done. Once you assume the responsibility of a caretaker, you also have the responsibility of making arrangements for future care if you desist from continuing to provide care.
Just, I don't know, it's a continuation of this. I'm a caretaker at a facility. If I have reason to suspect that one of our clients is being emotionally or physically abused by a parent, and they go home on a visit, is this something that I
Yes.
may need to report?
You don't have to be a direct witness of the abusive act in order to report it. You just simply have to have a suspicion that abuse has occurred.
Well, thank you for coming and thank you for your questions.